to a lot of bad behavior, right? Which you see in your courtroom, right?
Yes, absolutely.
Okay. All right, fine. So now, in the criminal docket, I think people have a really good idea. You go out and the criminal robs a store, okay, and then the criminal is caught by the police. What happens then, and from the moment that they're caught by the police, how does it wind up eventually in front of you?
Well, the state's attorney would file the charges, and after those charges are filed, if those people are arrested, they're actually in custody. If they're not arrested at that time, they're given a court date. And they come to court, or we see them on video if they're in custody, and we give them their first advisement, which means I'm giving them their rights that they have. Now that you're in custody, or now that you've been charged.
You have the right to shut up.
Right.
Yeah.
Exactly. That's one of them. You have a right to remain silent, you know. So that's how it ends up in front of me for the first time, and then we reset them for a new court date, and they either plead guilty or not guilty. That's called an arraignment. And then the offers begin, and, you know, the state provides discovery, which are the police reports and things like that that they have, that they will use to prosecute this person.
And how do judges make a determination? Okay, so somebody has gone into a convenience store that's attached to a gas station, and they came in at 11 o'clock at night. They put a gun, said, hey, give me the money. The guy, of course, turns over all the money because they're advised, don't fight, just give them the money. How do you then decide, I mean, how much punishment they get? I mean, do you have, like, handbooks that say, you know, rob a convenience store at gunpoint, you get this, rob a convenience store without a gun, you get that, or how does that work?
Well, the legislature makes the laws. As judges, we interpret those laws. So the legislature actually sets forth in the statutes what different classifications of crime, the potential sentence you could have for that. So we have a range of sentence based on the classification of the crime, and then there are add-ons if you use a gun and those types of things that have to be taken into account too. But mainly it's by statute, and we have to follow that, and it's a pretty large range most of the time.
Is it really?
Yes. So,
for example, what would a range, for the case that I just invented, what would a range be?
Well, it depends on the classification of the crime. Like,
well, basically what I described.
Right.
A guy shows up at over 18.
Right.
Shows up at a convenience store, and, you know, either indicates has a gun or shows the gun. Give me the money.
Right. Well, it depends on what classification the state's attorney charges that as. I'm not responsible for charging a crime, so they would charge it. For example, a Class 4 felony, you could have anywhere from probation all the way up to, it's 1 to 3 years in the ordinary range for imprisonment for that crime. It could be 3 to 6 years if it ends up in the extended range. And there are sometimes some extenuating factors, circumstances, prior criminal offenses that could land you in the extended term range.
In Illinois, is having the gun or indicating you have a gun, is that get you more time, or that is no never matter?
And it depends on exactly what occurred in that particular case, what the add-on penalty could be. So
I see. So, and if in the judge's opinion that the state's attorney didn't charge right, do you have any say in that matter?
No. I mean, the state is responsible for prosecuting someone, not the judge. So the state will actually file the charge. The state will it will have the penalty on there, what classification that it is, and then the judge is confined to those charges. I mean, we do not file the charges.
So that brings us to the next interesting question. What is the role of the judge then?
The role of the judge is to be a neutral person, to be impartial. We're not for the prosecution. We're not for the criminal defendant. Our job is to make sure that constitutional rights are not violated in a case, and that we proceed and have the case move in an expeditious manner and make sure that everyone is treated the same. We treat the state's information the same as we do the defendant's.
Mm-hmm. Now, judges can be finders of fact also, though, in the case of if there's no jury, right?
Right. We have bench trials more people are familiar with the jury trial because that's what you see on TV.
Right.
There are actually very few jury trials where I live, and because of our population being what it is. And the bench trial is actually where the judge would be the finder of fact, not the jury.
Mm-hmm. So you have to go back to old movies to see that, where the judges actually say, "Hey, come on up here." So, did you go and drink that whiskey that didn't belong to you? And yeah, I did it. Right.
Right, and it might surprise a lot of people to discover that most people plead guilty. I mean, so
but they are.
Well, they say they are. I have to believe them. So
that's an interesting point that you just made. So the judge, you have two roles then, as a neutral who interprets law. Is that correct?
That's what judges do.
And enforce law too. Or
sometimes we have to enforce the court's orders that are entered. Like I said, most people plead guilty. Or you can have an order after a jury trial or after a bench trial where there's a certain sentence that you're supposed to serve. But most of the time you receive a guilty plea, which means that the state and the defendant have come up with an agreement. And that agreement is memorialized in a writing, and then as a judge I'm required to go through and tell someone what rights they're waiving when they plead guilty. And then sometimes there are some collateral consequences, such as if you're not a citizen of the United States, you can be deported, things of that nature, and then I'm supposed to give them appeal rights also. So what most people don't understand is there are all the discretion of the judge in that particular type of a case, which is what we see the most often, is that I have to look at it and say, does this look like a fair agreement, just based on what's here in front of me? Because you don't receive testimony, you're not advised of, you don't have any other information except what's being presented to you in the charge. So,
how much do you read? I mean, there are police reports. There are, probation reports, etc.
Right.
Do you get all that to look at, even if there's a guilty plea?
No, you do not.
You don't. So you really are flying blind then.
Yes, you're just looking at what's being alleged. You listen to what the factual basis is for what the state's attorney has charged. The defendant agrees that that's the factual basis, and that's what would come out if that was testified to at trial. And then you go through the admonishments, asking them if they understand various things and making sure that they were not coerced into pleading guilty. I have to make sure of that before I accept the plea.
Mm-hmm. Have you ever found anybody that felt that they had been
coerced
into pleading guilty?
I've never had anyone tell me that, and I ask every single time I have a guilty plea, and I've never had anyone say yes.
So the state's attorney's office is really a very powerful force then.
Absolutely.
They're the ones that are, I guess, in charge of, almost like what's in charge of enforcing the law.
Right, and I mean, a lot of people don't understand that the state's attorney's office, they really aren't there just to press charges and punish. I mean, their job is to make sure that justice is done. So sometimes that means that they have to dismiss charges that they find are not founded. And after they charge people, sometimes they do some investigation and discover that they don't have enough evidence to move forward with that case, so they will ask that it be dismissed.
Mm-hmm. Is it ever happened that the agreements between the defendant and the state's attorney in terms of punishment are unacceptable to the judge?
From time to time.
And is there anything you can do about that at that point?
You can say you're not accepting the plea, and you don't have to really say why. You can just say, I won't accept that plea. Either you think the punishment is not high enough, maybe you think the punishment is really high for maybe a person of that particular age. If it's a person that's young, like 18 or 19 years old, I mean, there are two ways, I have seen it in the past and have experienced myself, so where it's not acceptable.
Right. And you have been on the other side, too, as a defender, a public defender, haven't you?
Yes. Most of my experience, though, was at the appellate level.
Yes.
So that's a little bit different than the circuit court level and what you're talking about.
Explain the difference to people between, again, television, they know what a public defender is, they've seen they believe they've seen what a public defender does, although that's just television or movies.
Right.
But when you get to the appellate level, there's no big speeches or anything, is there?
No. Actually, what happens is if you live in if you can just imagine any circuit court that could be in your county, if you would lose that case for some reason and you wanted to have some other judges look at it because you believe that you were harmed or you were treated improperly or the court didn't follow the law for some reason, any issue that you might have, you can appeal that to the appellate court, and you have 30 days to do that. If you live anywhere in southern Illinois, there are 37 counties in southern Illinois, so any of the circuit courts in those counties, those cases would be appealed to the 5th District Appellate Court, which is in Mount Vernon, Illinois. And there are 5 different appellate districts in the state of Illinois, and the 5th District Appellate Court is the southernmost one. So when you have a case before the appellate court, you basically, if you're the person appealing, you're called the appellant. And you basically have to file a brief and you have to explain what the facts of the case are, and then you have to write up the issues. You know, the trial court erred because of X, and I don't think I was treated right because of Y. I mean, and then the appellate court they have 30 days before the appellee, the person responding on the other side, they have an opportunity to write a brief and respond to those issues.
That would be the state's attorney's office, most likely?
Most of the time. It's usually in a criminal case, it's usually a defendant who is appealing. There are state appeals sometimes if the state loses and they appeal, but it's more common that it's the criminal defendant that's appealing. So as an appellate defender, like I was the deputy in the state appellate defender's office for the 5th District, those attorneys actually are writing the brief where they're raising the issues most of the time. The state's attorney's office or the state appellate prosecutor, they respond, and then the appellate defender's office, you get an opportunity to file a reply brief to whatever the state argued. Then that case is set for an oral argument in front of the appellate court. And there are 7 appellate court judges. 6 of those judges are elected judges. They hear cases in panels of 3, so you wouldn't have all of them listening to your case. The cases are randomly assigned to 3 different appellate court judges by the clerk of the appellate court. And that person is in Mount Vernon, and they kind of oversee the building in Mount Vernon, and then they oversee the dockets and randomly assign those cases. So by the time you have your case go in front of 3 appellate court judges, they've already read your briefs, they know what the issues are, they're very well versed on what the topic is and the issues are before them.
Have they read the transcript of the trial, assuming there is one?
Some of the judges' dockets are in a position where many of them probably have done that. Some of them maybe not. It just depends on the judge and how their office is running at the time and how their docket is.
So you mentioned an error by the court. In that case, that's you now, right?
Yes, I'm a circuit court judge,
right.
so that could
error,
be me.
And what would be considered an error, a reversible error by a judge?
If the trial judge has a lot of discretion in various kinds of cases.
You mean like allowing in or excluding evidence? Right,
and even maybe even in sentencing someone, the court could err because it didn't consider certain factors that the legislature has basically set forth that we are supposed to consider as judges, those types of issues. So when those issues are briefed and they go before the appellate court judges, then as the state appellate defender, then you get up in front of these judges and you start making an argument. You tell them a little bit about the facts to kind of just, brush them up on what the facts are. And then you go ahead and you start talking about your issues and you explain to the court why you believe that your client was wronged in some way. The appellate court judges just basically interrupt you during your argument and ask you questions the whole time you're there. You have a certain amount of time that you're allowed to do that. And then the other side, the appellee, they